Welcome to Expert Views on EDR EVA, a podcast about simplifying the traditional African method of settling disputes or the appropriate dispute resolution (ADR) in a bid to attract more users to settle their disputes or conflicts with mediation, ombuds, collaborative law, arbitration, restorative justice, early dispute resolution, negotiation, conciliation, and of course, early neutral evaluation. My name is DrChinweEgbunike, the marketing liaison of Ombuds Day 2024 American Bar Association Dispute Resolution and the host of Expert Views on EDR EVA video podcast show. I'm delighted to welcome Ellie Vilendrer to the EVA show. I hope I got that correctly. She's the co-chair. Yeah, carry on.
No, I was going to say, do you speak French?
A little bit.
Okay, because you pronounced it the authentic French way. It's a French last name, and that's the correct way of saying it. Although, most people say Vilendrer, but I was delighted you said Vilendrer. Thank you.
Je parle français un peu.
Très bien.
Merci beaucoup. Okay, she's the co-chair of the Early Dispute Resolution EDR Committee of the American Bar Association ABA Dispute Resolution Section and Vice Chair of the Orange County Bar Association Legislative Resolutions Committee. She is also an appointed fellow of the American Bar Foundation, an arbitrator, mediator, settlement counsel, and a Southern California super lawyer in ADR. Ellie wears many hats. I've left the link to her profile below. Let me stop sharing now. Welcome to the show, Ellie.
Thank you so much for having me, Chinwe. I'm delighted to be here.
Oh, thank you so very much for honoring the invitation, because this is the first time I'm having a leader in the field speak to us about EDR. So I'm super excited and grateful.
Thank you, me as well.
Okay, so without further ado, the first question is, what is early dispute resolution?
All right,
EDR?
Well, early dispute resolution is basically time-efficient and cost-effective dispute resolution. So we're all very familiar with ADR, alternative dispute resolution, or as you like to say, appropriate dispute resolution, and I love that.
Yeah.
It's ADR, but it's the focus on using it is early in the life cycle of a dispute. So ADR is most effective, it's most valuable, I should say, when it's used early. And so that's why we call this early dispute resolution. So ADR is widely used. If you look at statistics, you'll often see 95 to 98% of cases settle before trial. So they are using ADR in most cases to resolve cases, but they're not using it as early as it could be used. And so, our whole practice in EDR is to try to help people get used to using it earlier as appropriate. And when we talk about what early is, early can mean multiple things. It can mean after a lawsuit has been filed and it's still early in the case. Not a lot of activity has happened. It might be the first 3 or 4 months. It could be before a lawsuit is filed. And it could even be dispute prevention. That also falls under the umbrella of early dispute resolution. And when we think of early dispute resolution, we're thinking of processes and methods where the parties retain control. There's certainly, like arbitration, can definitely be cost effective, can definitely be efficient. We're usually talking about party directed processes like negotiation, mediation, the use of ombuds, the use of settlement counsel. And the benefits to that beyond party control is certainty, preserved relationships. You can craft creative solutions. There's lower costs. So really there's a host of benefits to doing that. But I'll say it's an intentional problem-solving process, and really done well, it's a collaborative, a joint problem-solving process.
Thank you so very much. So what I hear you say is that it's still the informal methods, processes, but the focus is for us to use it earlier than using it later or subsequently.
Right. The focus is on efficiency, because when you're because the process of resolving a dispute has costs, whether it's attorney's fees, your time, the drain on your emotion, the distraction, there's tangible and intangible costs. So by focusing on efficiency, we create more value for the parties.
Okay, so focusing on efficiency. So that's why we should use EDR.
Well, yeah, I mean, that's
one of the reasons.
I mean, it's valuable for the parties who use it, and we can get into this more later, but it's also valuable to parties who don't use it, because they are going to benefit from a reduction in congestion in the courts.
Okay, so that leads me to, so what are the advantages and disadvantages of using EDR?
Well, the advantages are party control, you have creative solutions, the preserved relationships. There aren't disadvantages. It may not always be the right time. It may not always be effective for every case or appropriate for every case to use EDR, but there are not disadvantages to using it.
Okay, so no disadvantages. It's, in essence, it's you have to maybe speak to your lawyer, or do your research before you decide to choose any one of the processes.
Definitely, it should be informed. And I'll say, even if you're not able to resolve a case and you try to resolve a case early and you're not able to, you're still building a relationship with the other side. You're building trust. You're opening the doors of communication. You're making it easier to resolve the case later down the line.
Okay, thank you so very much, Ellie. So how did you get into EDR, if I may ask?
Yeah, absolutely. For me, the spark was lit in law school when I took a negotiation class from a professor who had taught at Harvard's famous program on negotiation.
Wow.
And I just became so interested and excited about value creation. I'll say that I have an undergrad degree in business with a concentration in corporate finance. I had taken lots of economics courses. So I was already economics oriented. But it was so fascinating to me that this process was something that could create all these benefits, as we've been talking about. And it also incorporates psychology, which is, it's a social science. I'm very drawn to the social sciences. So that's where it started. I knew I was going to do something with it. I wasn't sure exactly how and when. I started practicing in litigation at law firms, exclusively practicing litigation for my first 6 years of practice. I did general civil litigation. I handled personal injury cases. I handled commercial cases, just a wide assortment. And I realized my favorite thing to do was go to mediation. But I also had kind of another aha moment, which was in handling catastrophic injury cases. I was seeing that these parties who had already suffered these horrendous life-altering events were sometimes now having to go through a secondhand trauma or another trauma in going through this protracted litigation. And in a lot of situations, I thought that those cases could have been settled earlier. So I went on, I started my own law practice. I did, so this is 11 years ago now. I continued to litigate, but I wanted to also have a focus on early dispute resolution to see if I could help parties resolve their cases early. I focused on commercial cases and employment cases, and I was very successful in getting those cases resolved. I also just totally immersed myself in the study of game theory, negotiation, psychology, behavioral economics, neuroscience. I was writing about negotiations. I was teaching negotiations. And so I dove into it. And then 4 years ago, I became the co-chair of the ABA's Early Dispute Resolution Committee, and became an arbitrator, became a judge pro tem, handling mandatory settlement conferences, a lot of mediation. So here I am today, almost 20 years after taking my first negotiations class.
Wow, awesome. And also you're a fellow of the American Bar Foundation. You're into research as well. Because some of the resolutions, you sort of spearheaded them.
I am actually doing research, but not with the American Bar Foundation.
Okay.
I have a research project in which I collected survey responses from over 300 attorneys and looking at how cases were resolved under different mechanisms and kind of the value that was derived from the different mechanisms. So, I am very interested in research in dispute resolution and working on it.
Okay, thank you so very much for that. So, what kind of disputes or conflicts can EDR resolve?
So, EDR can resolve all kinds of disputes. So I've successfully used it a lot in commercial and employment cases. It's widely used in construction cases. I'll say in the construction industry, they're quite advanced in dispute resolution. They use things like dispute resolution boards where they focus on dispute prevention, which is really outstanding. And they have people kind of monitoring the project to make sure small issues don't blow up into big problems. It's very well suited for family law cases. So when you think about divorcing spouses that are actually using the family assets to fight over the family assets, you could see how valuable that is. And very sadly, sometimes they're using the children's college savings just to fight. So it's tremendously valuable in family cases. It can be used in personal injury, consumer cases, really all types of cases. It can be used in all case sizes as well. I've used it in large cases and, multi-million-dollar cases. It's suitable for that. But I will say that often enough, it is the only reasonable path, such as in small cases where the stakes just don't warrant the spend.
Thank you so much, Ellie. How about in criminal law? Can it be used in criminal law?
Yeah, and I'm not a criminal lawyer, but I have spoken with criminal lawyers. I spoke with a criminal judge who is very fascinated by EDR and wanting to incorporate that in her courtroom, and as well as criminal lawyers too.
Okay, thank you so very much. So, what do you think? Has EDR enhanced access to justice in the US, precisely in California?
EDR does enhance access to justice because when you look at litigation, it can absolutely be a competition of resources. And for those with less resources, this can even the playing field. Also, there are lots and lots and lots of unrepresented litigants, so litigants who don't have lawyers. And the legal system is very complex to navigate, and it can be very difficult for a not represented party to navigate that system. So early dispute resolution is more user-friendly and more accessible. And then also, and we can talk about California, we will talk about California because I believe it has the worst statistics in the country in terms of court backlogs. But it takes so long to get a case to trial because of the court congestion. The justice is more accessible when you can control the timeline and the terms of the resolution.
Yeah, thank you so very much. So that leads me to this question about the impact, or if there is any measurable difference between the cost and time frame for settling under EDR when compared to litigation. Thank you.
Yes, Chinwe. Well, absolutely. The time component is very easy to compare if you're resolving a case pre-litigation or within the first 3 months versus in 2 years or more. You can definitely see the time difference, but also cost savings. If you are avoiding numerous depositions, filing motions, hiring experts, trial preparation, you're going to save a lot more money. And that is actually something that I'm looking at in the study that I'm working on, is actually comparing the value of the outcomes based on these different mechanisms and when the cases are resolved.
Oh, okay. Thank you so very much. So that means that the advantages of settling under EDR outweighs that of litigation. Okay. Did you get that?
No, I'm sorry.
So that means that the advantages of settling under EDR outweighs that of
outweighs.
Yeah.
Yes, it does. I mean, as long as you're not sacrificing a good deal to do it, which of course, we're not going to just, I'll take whatever you're going to offer me, or, something like that. This is educated and it's informed dispute resolution. So when you're getting something, the whole point is to get an outcome that's better than you would if you're going to trial. If you can do better going to trial, then you go to trial. But the whole point, and of course that is net of, you got to look at all the costs that it's going to take you. But otherwise, yes, in most instances, you will do better using EDR.
Okay, thank you very much, Ellie. So I'm interested in understanding EDR's working process and how parties can initiate action via EDR.
Well, I will say, number one, it starts with thorough preparation. Before you do anything, you have to get a very good understanding of the facts that you can. Get enough information, but not perfect information. So review the documents you have, talk to the witnesses you have, study the relevant law, and really get your head wrapped around that. So we call it that, doing an objective case evaluation, where you're looking at it not just like as an advocate and how I'm going to try to be persuasive with this, but really objectively, what is this case worth, or what is the potential exposure? You can do what's called a risk analysis to understand that potential exposure and evaluate that and your expected outcome at trial. And once you really feel like you're prepared with what you have, then you reach out to the other side, and you can arrange an early mediation, or you can just talk directly and directly negotiate. You can hire settlement counsel. So I did this a lot in my law practice. Yeah. I would, prepare. I would create a big 3-ring notebook full of exhibits, tabbed, like I'm going to trial, call the other side, arrange for an in-person meeting. It was a friendly meeting. This was not like an adversarial type thing, but I'd say, can we talk about this? Can we work it out? These are the facts I'm relying on. What are you relying on? And most times I'd say the other side did not have key information because they had not done that upfront preparation like I had. Yeah. And it was so useful because I was able to give that information. We were able to work out an early resolution because they had the information they needed. And sometimes I got information that I needed that I didn't have, but it works out in most situations to end up being a collaborative joint problem solving process. I find that most people are willing to do that. Yeah. I find that most people are reasonable. Some are not, and sometimes you have to fight, but most people are reasonable, and most times you can get a very good outcome doing that.
Thank you so very much. So what are the simple steps for parties to approach EDR?
To approach it, if they have a case.
Oh, yes.
Like a case. So I would say, just reach out after you do your preparation, reach out to the other side, arrange a face-to-face meeting, because you can really cultivate trust a lot better face-to-face if you can. If you can't, try to do Zoom. But, if you're just sending these aggressive letters back and forth, you're not going to create that kind of relationship that you want to foster, collaboration and joint problem solving.
Okay, thank you so very much. And so I know in recent years, the ABA, American Bar Association Dispute Resolution, House of Delegates approved Resolution 500, Can you elaborate on its significance and what was the state of ADR before the approval?
Yeah, thanks so much, Chinwe, for asking about that. Resolution 500 was unanimously adopted in February by the American Bar Association House of Delegates. It urges the increased, informed, and voluntary use of early dispute resolution, which is, methods that we talked about, such as direct negotiation, mediation, and ombuds. It was spearheaded by a team including myself, Mary Cullen of Minnesota, Felicia Harris-Haas of Texas, and Meg Willoughby of Pennsylvania. And, for all the reasons we've talked about, all the benefits we've talked about, we brought this forward. But something that's super compelling, which caught everyone's attention, is the status of the backlogs. So one of the statistics we brought up was between 2019 and 2023, the backlog in federal civil courts grew by more than 80%, from almost 360,000 to almost 657,000. And everyone's jaw dropped really at hearing that, because that's tremendous growth in a very short time period. But state courts are even more stretched for resources. And because of that, judges have very heavy caseloads and litigants have to wait a really long time for trial. So, as we talked about, 98% of cases are settling, but they don't need to settle so late. If they settle earlier in the process, it's going to really help to clear up the court congestion and preserve the parties' fundamental rights to timely adjudication, because most cases don't have to be there, some cases really do have to be there, and it's vital that they get to try their case in a timely fashion.
Thank you so very much, Ellie. I know it's too short to conduct a data analysis to find out if there has been improvement so far from February to date. I don't know.
I don't know that we're in such a short time period going to see that. I think it's really more of a culture shift. That's what we're going for. We have such an adversarial culture. That we really need to shift that, because there are just too many conflicts out there. There are just too many. And there is a better way for all of us.
Okay, thank you so very much. Can you also tell us about the Senate Bill 1141 and its importance?
Yes, thank you, Chinwe. So this is California Senate Bill 1141, is a bill that I originated in resolution form about 15 months ago as a member of the Conference of California Bar Associations. What it does is it increases the ability of courts to refer cases to mediation. So currently they can order a case to mediation where the amount in controversy is between $35,000 and $50,000. It's a very, very narrow margin. This would increase that to $150,000. And I did that because California courts have really, really, really bad court congestion. I'll get to that in a moment. But after it passed there unanimously in the Conference of California Bar Associations, then I got Senator Nilo to back it, and it has now passed 38-0 in the Senate. And in 2 weeks, I'll be going back to Sacramento to testify for the Assembly, and it will need to make its way through there. But why did we do it? So California, I told you about the 80% increase. So it was about 300,000 cases increased in federal court. Well, in California, in the last 5 years, the civil court backlog has increased by over 1 million cases. That is way more than the whole federal system in California. It's way more. We have 12% of the country's population, but 60% of the country's litigation. We are not meeting any of our case disposition goals, not the 12-month, not the 18-month, not the 2-year. And so the Judicial Council of California is behind this. LA County Superior Court is behind this. A number of other organizations support this because they want to promote time efficient and cost effective resolution and ensure timely adjudication of cases. And the research behind it is that mandatory mediation is effective. There was a program of 5 court annex mediation programs between 2000 and 2003 in California, which culminated in a 445-page report. And in the report, they said all 5 mandatory, well, 2 of them were voluntary, 3 were mandatory, but all 5 programs were successful. They resulted in substantial benefits to litigants and the courts, including increases in litigant satisfaction with the court services and decreases in litigant costs in cases that resolved in mediation. In San Diego, it had saved 521 trial days per year. In Los Angeles, it saved 670 trial days per year. And the settlement rates were high. They were in the high 50s to the high 70s. So it was around 2/3 of the cases were settling at early mediation. At early mandatory mediation. And of the minority of cases that didn't settle, most of those cases said that it was beneficial still, and it was important to the ultimate settlement of the case. In San Diego, 74% of the cases that did not resolve, the party said it was beneficial. And in Sonoma County, 90% of the ones that did not settle say it was beneficial. So for those reasons, we've brought it forward and we have a lot of support on it.
Oh, thank you so very much, Ellie. I wanted to ask a question following what you've just said about the backlog and what the California government per se has done so far. My question is, could you say that the parties are yet to embrace ADR and their lawyers as well? Because you find out in some jurisdictions, these are the case. The parties do not know about ADR, and of course the lawyers are not willing to share the information or encourage them to, settle via ADR. Is that the case? Is that why we've got so much backlog in California, or one of the reasons?
Well, I don't think it's that they're not using ADR. I think it's that they're not using EDR. That's the problem. So and in the past 3 years, Chinwe, we've had more than double the filings of civil cases than we've had dispositions. We have a lot of volume of cases. So we need to fit the process to the problem. And most of these, they don't really require a judge to make a decision. We can rely on ourselves to do that in so many of the situations.
Okay, thank you so very much. So the final question is, what is
I'm sorry, Chinwe, could I make one more point?
Oh, yeah.
On that, I think it's important to the dialogue.
Okay.
It's so because in California, the judges are seeing such an increase in their backlog or in their caseloads. It was typical for a judge to have 600 cases. Now they're having over 1,000 or 1,200. And what happens then is that it's causing judges to retire. And when judges retire, it causes heavier caseloads for the other judges that remain. So we also have a budget problem. We have a shortage of resource problem. So, it's not that they're not using ADR. It's just that we need more people to use it earlier.
Okay, thank you so very much. So how about the lawyers? I'm really curious, have they embraced EDR?
They are more and more. Even over the last 4 years that I've been co-chair, I've seen so much more reception to it. It's really great to see. I do think in the next decade, we're going to see a big culture shift. So everyone's efforts are working.
That's what I was about to say. The work the AB82 resolution has also put into making ADR more universally accepted. They've done a great job, and of course,
definitely.
Yeah.
Definitely. The section has done a really wonderful job.
Yeah.
And, people like you too, Chinwe, who are working
Thank you.
tirelessly to get the word out. So, thank you to everybody who's working on the movement.
And you too, Ellie. All the research you've put into making the resolutions possible materialize. It's really commendable. Well done. And the final question, I think we're running out of time, is what is your advice for people who would want to pursue a career in EDR?
I would say study negotiation strategy for sure. Study adjacent social sciences, study mediation. If you're going to be wanting to resolve legal disputes, you have to be well versed in the relevant law. Never stop learning, join bar associations, and read a lot. And I'll just, a few of my favorite books I thought I'd mention. Thanks for the feedback. Difficult Conversations, Deal Making, The New Strategy of Negotiations, Thinking Fast and Slow, Getting to Yes, Getting Past No, Never Split the Difference, Good for You, Great for Me. There's more, but those were my favorites.
Thank you so very much, Ellie. I'm going to check out some of these books, especially thank you for the feedback.
Yeah, I love that book. It's awesome. Everyone should read it.
Oh, thank you so very much. Oh my goodness. Thank you for coming on the show.
Thank you. It's been such a pleasure being able to speak with you today.
Oh, same here. This, of course, has been a masterclass, or is a masterclass. I totally learned so much from you. And of course, I know that potential users would embrace when they listen to this section. And of course, opt for EDR whenever the need arises. Thank you so very much, Ellie, for coming on the show. I'm so grateful. Thank you for your insights, perspectives, and the learning you shared with us. I needed to say that because that's like a sort of closing line for me. So, yeah, thank you so much.
I guess we should say abiento.
Abiento. Au revoir. Yeah, abiento. Merci beaucoup. Bye. Au revoir.
Bye.
Cheers.
Cheers.